The war on your car and electric vehicles may come to an end because the electric vehicle mandate versus the people have now reached the United States Supreme Court. They have agreed to hear the case and the challenges on whether the U.S. Environmental Protection Agency can let California impose emission standards that are stricter than those enforced by the federal government. Now, this is a fight I've been talking about for quite a while, and the electric vehicle mandate versus the people is the fight that we want. And I'll tell you what's going on and why, but first I want to remind you to like this video and subscribe to this channel to keep up on what's going on in the automotive world. The Supreme Court case is being brought by Ohio and 16 other Republican-led states who claim that by letting California set its own emission standards, the federal government, or more specifically the EPA, is allowing the state to operate as a quasi-federal regulator pertaining to global climate change. The California Air Resources Board, known as CARB, has increased its power under the Obama administration, and it continues to gain power. And this is where it went too far. In addition to the 17 attorneys general, the rule is also being challenged by fuel producers and sellers based on the argument that the demand for their products are being hampered by California's separate and stricter laws. The impact to the economy and jobs is much larger than the media ever discusses. And under the Clean Air Act of 1967, the federal government set emission standards that California later argued were not stringent enough because the state's smog problem. That's their problem and needs to be cleaned up on a state level. And when California subsequently enacted stricter standards, auto manufacturers balked, claiming it was prohibitive and expensive to deal with the unique emission standards of just one state. Well, the government offered a compromise, enabling states to either adhere to the federal standards or adopt their own emission standards that were identical to those that were enforced in California. They're never going to build one car just for California or 17 states. It's one car for the United States. And this was accomplished through the waiver system established by the EPA, which later became known as the California waiver. The California waiver was withdrawn under the first Trump administration. He waited too late into his term to make that happen, and I'm hoping that this time they'll get on it right away. And it was challenged by the state of California, and it was left unresolved. And when Biden became president, at that time, he made the EPA reinstate the waiver, allowing California to enforce even stricter tailpipe standards. Now, in addition to Ohio, the other states participating in the lawsuit include Alabama, Arkansas, Georgia, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, Oklahoma, South Carolina, Texas, Utah, and West Virginia. That's pretty much all the states that are not complying. But no states are on track to meet the Advanced Clean Car 2 Act of 2026. That target cannot be reached, but they continue to make the standards even higher. Chet Thompson of AFPM president and CEO stated that, in quote, "We are very pleased with the United States Supreme Court has agreed to grant the cert on a very important case. The drastic impact of California's EV mandate on consumers, national security, and electricity reliability are major questions in need of immediate resolution as California and the U.S. EPA continue to stretch and abuse the limits of Congress's Clean Air Act waiver provision. Congress did not give California special authority to regulate greenhouse gases, mandate electric vehicles, or ban new gas sales, all of which the state is attempting to do through the intentional misreading of the statute. We look forward to our day in court." Close quote. Now, this also includes that RV mandate we've talked about in previous videos. You can check that out up here because they're going to stop them from selling gasoline and diesel-powered motorhomes. That's going to impact the economy as well. And this is all under this same California waiver. Now, in June, AFPM and a coalition of 15 energy, agricultural, and biofuel groups filed a petition for a writ of certiorari, which is a cert petition, with the Supreme Court challenging the EPA's decision to grant a waiver to the state of California for its 2021 to 2025 Advanced Clean Cars Act, electric vehicle sales mandate, and a policy that interfered with the vehicle choices available for nearly 35% of Americans directly and many more indirectly. Now they will have their day in court. The goal is to have the Supreme Court step in, remove, and overturn this ruling. This would challenge the EPA's issuance of the federal waiver allowing California to impose its Advanced Clean Car 1 EV mandate. The California waiver in the Clean Air Act does not empower one state to regulate vehicle greenhouse gases and emissions and impose electric vehicle mandates or limit your choice to access internal combustion engine technology. This waiver is unconstitutional and it needs to be overturned and remove CARB's powers. In addition, a coalition of 24 states also petitioned SCOTUS, the Supreme Court, to review California's regulations. We will be watching and reporting the results of the Supreme Court case that impacts your choice for vehicles. Now is the time to turn this over and dissolve the California Air Resources Board. If you like this video, give it a like and subscribe for more videos like this, and check out our car review channel, Car Smarts. You can support me by buying me a cup of coffee, and if you want even more content, check out the links in the description. I'm Lauren Fix. Thank you so much for watching.